Okay, Ryan, would you like to lead off our first slide and introduce yourself?
Thank you, Jeff. I'm happy to partner with you and with the Society of Physician Entrepreneurs to bring some experts who know a lot about strategic partnerships in the biotech space and pharma, and specifically today to talk about the art of crafting a non-binding term sheet. And as we move in, I'd just like to do a quick introduction for the GWTCO, the Technology Commercialization Office. Next slide, please. So we're where the journey goes from the lab to the world here at George Washington University. This is our team. We're really excited to get in touch with you and help you to join our community. Please take a look at our website and technologies that are coming out and are available, and you can subscribe to those you are interested in to get updates. And you can also connect with us on our new LinkedIn page and find out about events like these and more technologies and awards. Next, please. And another way to connect with us is through our online community, which is GWCAN, the Commercialization Advising Network. It's a really easy place to ask questions and to give advice and help with people who are interested in building startups. So whether that's inventors or entrepreneurs, there are people here who are helping each other along, and you can be a part of that as members of the GW community. Next, please. I want to highlight a couple of our programs that we have to develop technologies coming out of our pipeline. We're investing money into de-risk technologies and to help startups that take licenses. Just this past year, we gave out 4 $50,000 awards to do that de-risking in-house. And so there's some pretty cool technologies that are coming out of that. And we had an innovation competition. Hopefully we saw you in person in April and gave out 40,000 prizes there in prizes. Just this month, we're launching an SBIR matching fund. So if you have licensed technology from GW and you've either sponsored research with us or you're subbing a SBIR or STTR phase 1, then we're willing to match that 2-to-1 up to $100,000. So we're excited to be your partner and help move technology along at the earliest stage. And then also in partnership with SoPE and with Pismo Ventures, we had a fantastic pitch event in March. We had about 100 companies nationwide in life science space applying to pitch to a large panel of investors. It's very exciting getting this together, and we're happy to support these kind of events where startups get those opportunities to get in front of investors. And I think, next slide, please. I'd also like to highlight a couple of our tools and resources that we provide to both build teams and to form these partnerships and make sure that you're getting your products targeted toward actual needs in the commercial space. So there's training available there and connections to be had, including the just announced Penn West Equity and Innovation District, which is a partnership between GW and the DC government, especially in the Golden Triangle business district. So a lot of opportunities here to connect and help build new ventures. And with that, I'll turn it over to Jeff, get our program started here and get us in the right frame of mind as we think about building these early stage biotech and pharma businesses.
Thank you, Brian. So many of you know that the Society of Physician Entrepreneurs is a global community of entrepreneurship, education, and connectivity, trying to teach anyone in healthcare about the opportunities and obstacles in bringing your innovation from your head to a patient. We have over 32,000 LinkedIn members, but a major component of our offerings are our local ecosystems. And we have over 25 chapters in many different portions of the United States and the world. I happen to run the Washington, D.C. and environs, the National Capital chapter, and have a close association to George Washington University, I am a clinical faculty member there, and I've taught medical students the art of surgery. And I'm happy that as I have transitioned into a new path in my career to share entrepreneur opportunities and learnings with the GW community. And sometimes you come across articles that really encapsulate really important learnings that you want to convey. I myself am on a path because I am the chairman of the board of a biotech company and their chief medical officer, and basically co-manage the company. It's called Biofactura. And we're on a path of commercializing novel as well as biosimilar products on many different fronts. And in that journey, you hit certain milestones and you learn things along the way. So let me share some of those things that I saw in this article. First, if we can go to the next slide. These are 5 mistakes to avoid when you're scaling your biotech startup. And this article interviewed this Frank Stonebanks of Renibus Therapeutics, who is quite knowledgeable and very succinct in his remarks, which is why I want to share them with you. Next slide. So surround yourself with the wrong people. You don't want to do that. You have to have the people who have the right mindset. That doesn't mean your mindset, but the right entrepreneurial mindset. And you need people who believe in the art of possible. If you have people who surround you who are just looking at everything and saying, I can't do that, they're not offering solutions. All they're doing is pointing out problems, and that's not the kind of people that move your product forward. So surround yourself with brilliant people and people who are smarter than you are in topics outside of your domain expertise. That's the way you will succeed. Because if you don't encourage, then solicit this diversity of expertise, the chances of failure go much higher. Next slide. Cutting corners. Well, when you're first starting, the thing you don't have is money. The thing you do have is time, but sometimes you spend so much time chasing after money that you wind up having neither. The operations team, by its very nature, constantly seeks to ways to reduce costs and improve timelines. But there is a not so fine line between the cutting costs and cutting corners. And if you cut too many corners, it can catch up to you. And when it happens, it can be catastrophic. And you may not realize it for many years down the line that something you did today to cut a corner will come back and bite you, resulting in a withdrawal of a drug or fines costing millions of dollars, or things that you just don't want to be dealing with, and you're basically kicking yourself for cutting that corner. So the bottom line is that you can't scale your company at the expense of doing what's right. Hard to do sometimes, but an important lesson for us to always keep in the front of our minds. Next. Focusing too much on your exit. Boy, how many of us spend a lot of time on hypothetical capitalization tables and the equity implications when you're pitching to investors? We obsess over potential exits and liquidity events. And it's really bad for business because we don't have the ability to engineer or plan your exit with any degree of accuracy. It really is smoke and mirrors. So focusing on exits distracts you from the things that you have to do today in order to reach that exit. So focus on building your product, helping your patients, and hiring the right people. You know, we had an exercise in our MBA class at Hopkins, and it talked about the mergers of 2 hospitals. And you had 60 people sitting down at different tables talking about all the implications of the operations, of the hiring, of the firing, of the stars in each clinical arena. But what you lacked was talking about the patient, the person who is receiving the care. And that was a major lesson for all of us in that room, and one that I keep teaching to entrepreneurs who are bringing these new innovations to market. Next slide. Chasing press too early. A lot of people think that press is the best thing in the world, but sometimes it's better to stay quiet and private and well-funded, and you look for press when you're looking to warm up the market with something that is newsworthy. So either before financing round or before an IPO, but let potential customers and partners or buyers really make the difference in what you're doing, not a press release. So use them judiciously, use them not frequently, but use them when you want to make a real statement because you've done something that deserves that statement. Next slide. Oh, we have one more slide, Joyce. While she's looking for that slide, I'll start the introduction to our panelists today and tell you that I too am on a journey with Biofactura, and the journey has taken us to a place where I am crafting non-binding term sheets and speaking to commercialization partners for our products. And in doing so, I engage my attorneys, Charles Andrews and Prashant Girinath of Greenberg, Traurig, to assist me in that journey. And as I'm doing this, I said, gee, I'm learning a lot of things here. I really should share my learnings with the SoPE community. So that's what we're here for today. And Joyce, if you haven't found it, that's fine. We'll just move on to the program. Is that okay? Okay. So losing sight of who you help. And this happens to be that same thing. Ask yourself, what is your passion for this space? And at the end of the day, that's the thing that matters. Helping people get better, whether it's a health IT app, whether it's a device, whether it's a biopharmaceutical, whether it's increasing the scope of your practice, everything else is just details. But if you keep that as your passion and have that culture as your passion in your business, the chances of you succeeding really go exponentially higher. So I thank you for listening to that little introduction. Let's get back to the introduction to our two esteemed attorneys here. Charles, could you please just tell the folks who you are, and then Prashant, if you can do the same, that would be wonderful. And then I will start peppering you with some questions.
All right, it sounds good, Jeff. Thank you. I'm an attorney, shareholder at Greenberg, Traurig, and obviously I work with Jeff, and we're very lucky to work with Jeff. He's doing some amazing things. Biofactura is a great company. I also work with Prashant, who's on the Zoom call here, and we focus our practice primarily in the biotech space, medical devices, drugs, pharmaceuticals, biologics, kind of diagnostics. That's our bread and butter. In terms of me personally, I've been doing this for, over 2 decades now. I've got 3 FDA approved drugs under my belt, which is fantastic. And we have a number of folks, clients, unicorns and otherwise, who are moving in that direction as well. And I've built and sold, with the help of very good teams and in partnership with companies, portfolios for an aggregate total of $10 billion, and equally have, as investor counsel, green lighted the investment of $10 billion. So it's a good 30-second summary. Prashant?
Thank you, Charlie. Thanks, Brian, Joyce, the GW team, and Jeff and the SoPE team for having us on board today. My name is Prashant Girinath. I'm a senior partner at Greenberg Traurig on the life sciences side, where I lead up, along with Charlie, a team of a little over 24 practitioners. The firm itself is about 2,500 attorneys globally. It's one of the big law firms out there. I like joking that if you need a lawyer for anything, or actually need a lawyer, or don't even need a lawyer for anything, I probably have 5 lawyers for everything you can think of. So that's a little bit about the firm. About myself, I have an undergraduate degree in chemical engineering, followed by a PhD in bio and medchem, and then a JD from Georgetown, a few blocks over from where Brian's sitting. Been doing what it is that we do for a little over a decade, and that's predominantly therapeutics and life science tools, mostly from the IP side, but we tend to be what I call the C-suite's best friend. We help in every element of the company build, and be it from financing to licensing to transactions to exits, and in each part of that journey, we try to be, as Jeff mentioned, counselors and trusted advisors moving the ball forward. We're 360 degrees when it comes to companies' needs. Charlie and I sit on the IP side, but we give a lot of advice on the IP plus portion, which is where these term sheets, I think, come in.
Thank you, Prashant. Thank you, Charlie. Okay, so we had some questions come in as to the definition of a non-binding term sheet. So Charlie, let you take this first. Could you define for the audience what is a non-binding term sheet?
I think globally, Jeff, it's a stage in a negotiation where you're thinking about engaging in a partnership or a deal with, for example, another company, and you're trying to define the key terms of that deal that matter to you and that matter to your potential partner. And by non-binding, what we mean is these term sheets, even though they all say legally non-binding, and Jeff, this will probably lead you into other questions, actually exist on a continuum. And so even though you've got the words not legally binding in the term sheet, depending on what's in there, some courts, if this were pushed, might find that the term sheet is legally binding. And we can maybe subsequently talk about how that works and why or why not. It may not be the case. But it's basically just a step in a process where ultimately you're trying to come to an agreement on important parameters of a future deal, which you can then subsequently go on to memorialize in a definitive agreement that gets signed by both parties.
And when you look at a non-binding term sheet, Prashant, can you give an overview as to what are the key elements that should be included in a non-binding term sheet?
Sure, Jeff. I'll start with the lawyer's answer of it depends. But having said that,
yeah,
it is true though. Each term sheet is going to be unique, and it's going to be tailored to the transaction we are approaching at that time, and that's very different from when it comes to, let's say, starting with a licensing term sheet, where one would do one with, say, Brian, going all the way to a joint development term sheet or even an M&A, right? So that being said, going back to what Charlie said, was the phase in the continuum, right? So what are ingredients in the term sheet? You're trying to lock down that 70–80% confidence mark on a transaction with a document that is not necessarily 30 pages long and does not involve lawyers running the meter on both sides, going down into every nook and cranny. So what do I mean by that? Look at a term sheet as the executives or the C-suite on both sides coming to an arrangement on what a transaction is going to look like and what are all the key aspects that are important at that top level. What are those and how to get those ironed out? So then the idea as to what we come out with a successful term sheet is both parties at relative ease that, you know, the most important things that are worried about, they have visibility on, and they have already negotiated as they go into the transaction. So in biotechs, what does that mean? Well, there's going to be structure with regard to who is paying for what, when are inflection points reached, what type of milestones are going to be involved, when is the payment or cash flow associated with that happening, and which party is taking care of that. Where are there in all of these, where are there tension points, and how do we kind of approach them? And then, of course, the important part is once revenue is generated, who gets how much, et cetera, et cetera. Somewhere in all of this is also contribution in kind or contribution in intellectual property that is to be accounted for. And then similarly, outcome with regard to intellectual property, et cetera. So these are all, the rough metes and bounds of what one would try to accomplish in a term sheet. In a biotech context, obviously depending on the company and the stage and the nature of the agreement.
So should the audience think of it as a period where you're dating or you're dancing with a partner until you get comfortable with that partner, and then if you like it, you better put a ring on it for the definitive agreement?
I would say so. I'd actually go a step further and say, going with the dancing with the partner, right? Both sides have put in a good amount of effort to get even to the term sheet part, right? You've had several conversations. You like what both sides are bringing to the table, and there is intent to try to get a deal done. And so the term sheet is the space where you codify that intent and try to hammer out enough specifics that both parties are walking away from the term sheet, kind of not having the paranoia that they're going to get robbed, because there is always power disparity going into these. And there's always, I've seen so many transactions typically start looking like they'll go sideways because the trust and the goodwill with which you approach the transaction starts eroding when people go into specifics and back and forth, because people aren't quite clear whose bright line is where and where is a no-go zone for each party. So the very nature of a negotiation is poking and prodding and trying to figure out what we can get out of it. And so it's important, as Jeff, as you mentioned, to stay in a dance and for it to not get hostile. And the term sheet is a good way to kind of codify all of that and make sure that the cadence in the conversation keeps going in the right direction. So that when there's a 40-page agreement or an 80-page agreement, at least we've codified all the important things going into it.
Okay, so Prashant, thank you for reviewing the elements that go in. Charlie, what are the things that you would never put into a non-binding term sheet, or that you would tell your client, this is probably something that you may want to reserve for a definitive agreement?
So Jeff, that's a great question. And I think, building on what you were saying earlier and what Prashant was saying, that we talked about a non-binding term sheet really being on a continuum where at one end it really is not legally binding, and at the other end a court might say, even though you have these magic words, I'm going to ignore those and I'm going to say this is binding, and it creates a contract. So one of the things, depending on how you want to do it, because you may be a party that wants it ultimately to be, legally binding. You may be Twitter, right? And the other party is Elon Musk. The more details that you put into a term sheet, the less that a court would have to fill in, the more likely a court will find that term sheet, if pressed, to be legally binding. So what you want to do is think about a couple of things. One is, what I really, if it came down to it, am I the party that really wants this to go forward? And, if I do, am I okay if it goes forward in a sort of hostile way, right? But, things that could trigger a court to go that way. Finances. When you start laying out extensive financial details, that's a big one for a court. A court is more likely to find something to be legally binding if that's in there. using certain terms. Like for example, if you use commercially reasonable, courts can say, okay, there's a whole list of things out here that normally you would have to agree to, but we have a general feel for what commercially reasonable means. And so we can kind of pull all of those in and say, maybe we filled in all the gaps. The flip side of that, Jeff, and I'm just going to take a little bit of a liberty here, is because you do worry that a court, if pressed, might find this to be binding, one of the things you absolutely want to have in it is a termination provision. You want to be able to say, okay, well, even if it is, I'm allowed to terminate this, and I'm invoking my termination provision, usually by sending written notice. And, along with that, you don't want, an undue delay. You don't want to say 6 months after receiving the notice, you'd like it to be more 30 days. And as a rule that can sometimes be helpful, you'd like to be able to terminate for any reason or no reason. So when you're crafting these, right, you also have to think, if I really want this deal to go forward, do I want to kind of push this in a direction where if it did go before a judge, it could be found to be legally binding?
Mm-hmm. So you make a very good point, Charlie, in that this doesn't lend itself to a template, which some of our participants have asked for, a template for a non-binding term sheet. Really, it has to be customized and individualized to the parties at hand and to the intent of the parties at hand.
That's correct. And that goes back to, I think, what Prashant was saying earlier about, intent. And so in a sense, right, these things ultimately depend on how you view the world, Jeff. If you like the idea of having a lot of freedom and being able to craft something that's custom made and it suits you and your dance partner, then term sheets can be an utter joy to work on. If you like very fixed rules and, very laid out routes, term sheets can be a little nerve-wracking. And so it's also good to know yourself and what your preferences are when you're thinking about walking in and doing one of these.
So part and parcel of creating and crafting a term sheet is based on collaborative negotiations between two parties. And usually that negotiation takes place between the parties and the lawyers are in the background at this point. Is that correct?
Again, this is also custom, Jeff, because, and I'd like to pull Prashant into this if it's okay, because
sure.
I think there are some other things that you want your lawyers to bring to the table with you. And Prashant, maybe you could talk about some of those.
Sure. Yeah, thanks, Traurig. So Jeff, one thing to mention, because there was some conversation about courts and there were questions about binding, non-binding. I want to say that, that those kind of situations are rare, right? To be in a spot where you've had a term sheet that two parties have agreed on, and then things have gone stylishly bad all the way to get the court involved. Many things have to go wrong. So I focus less on, in that sense, on is it legally binding, but rather think more in terms of, listen, we've gone through a process and we've achieved certain numbers that both parties have agreed on, and certain milestones that both, and certain kind of rubric to a deal that both parties have agreed on. Look at it as binding, because then if you start unwinding things that you've already agreed to, you're just leaving a very bad taste in the mouth for the other party as they approach a transaction. So less than legally binding is the idea that you have to take a non-binding term sheet seriously because the parties put in serious effort into it. And then if you start unwinding on one side, you're sending the wrong signal. So don't do it unless it's absolutely necessary. The world changes between a term sheet and a document, so things may change. It's okay to approach that again, but let it be an exception, and a very, very high bar exception. So with that said, now coming to your question, Jeff, and this is, the reason I started there was because the role of the lawyer has to be evolving with the circumstance. As you know, and as this panel is saying, if you give a mic to a lawyer, we're going to eat the mic, right? So it's important to keep us in the background, if possible, while trust is being built between the principals. Use us as a tool. Importantly, many times use us as the bad guys, right? You want to deliver a message, you're not quite sure you want to be the one delivering that message. Have us come and deliver that message, ideally in a nice way. Because we can speak about comps, we can speak about kind of norms, things like that, while you stay on, this is unique to me, the company, and this is what I'm trying to achieve.
Yes, Prashant, many times I have said my lawyers just won't let me do that, whether or not that's the case.
Right. So that's one aspect. And also get cues from the other side. If we're kind of discuss some of these smaller biotechs, many times we're partnering with large companies, big corporations. They may bring lawyers in early, which means what? There's going to be, questions that are more legal in nature. And it behooves at that time for you to say, hey, you know what? There's going to be a couple calls here where I'm just going to have my lawyers work with your lawyers and just kind of iron out some of the legalese elements. And that's perfectly fine. So Jeff, I think, we take the cadence of where the lawyer comes in really kind of depends on how each party is approaching it. And also what relations exist in the room beforehand, right? Many times when I'm in kind of pharma negotiations, especially in Boston, I see people I know really well on the legal side from the other end. Then there's already good relations. There's already some known faces in the room. There is already warmth. Well, that's a scenario where bringing us in early may be helpful because we know the people on the other side, and we can kind of, have offline conversation to say, hey, these sticking points need not be sticking points. Why are they even sticking points? Can you go talk to your guys and get them to the right cadence while we'll do the same on this side? So, it's really, I think to me, a term sheet is as much about the people who are putting it together as it is about the deal that's coming together.
Okay, thank you. I'm going to take us back to my schooling days at Hopkins when I was getting my MBA in order to highlight the art of negotiations when crafting a term sheet. And in negotiations, there's what's called positions and interests. And I'm going to read to the audience what the difference is between positions and interests. And then I'm going to ask Charlie and Prashant to talk about how they perceive this as a tool that they use and as a tool that can be leveraged or as a tool that could be destructive. So positions is what people say they want. Interest is why they want it. Positions are surface statements of where a person or an organization stands. They rarely provide insight into the underlying motivations, into the values, into the incentives, versus the interests are the party's underlying reasons, values, and motivations, and the interests explain why somebody takes a certain position. A position example is the union demands a 5-year contract. Bang your head on the table and that's it. I demand this. That's my position. The interest is that the union wants time for workers to retool their skills before the planned closings are implemented. So there's the reason for the position. So gentlemen, how do you see entrepreneurs using positions and interests, and how can they learn the parlance so that it is to their advantage in a negotiation?
So Jeff, I think, a good place to start with this is, if you're creating an environment where people feel comfortable and there's some degree of trust, as Prashant was saying earlier, we would sometimes call those pain points. And it's really important that you understand why someone wants something in a term sheet, right? Because you may not be able to give them what they want in the way that they want it. but you may be able to give them something that would equally suit their purpose, and then allow you to move past that pain point. If you can't drill down and really understand what's driving their position, then you lose that flexibility because they dig in on a particular term and they're very hard to move off that position once they've dug in. And this applies not just in term sheets, but it applies pretty much everywhere in life.
Mm-hmm.
You know, you really want to maintain that flexibility. And so you want to say, you know, tell us why this is here, what your underlying concern or pain point is, and then we can talk about a number of alternatives where we might be able to meet that. So I think, you know, from my perspective, like that's really, really important because it saves a ton of time on one hand. And as Prashant was saying earlier, you want these negotiations to be friendly. You want them to be cooperative. And so it prevents the injection of adversarialness into the process unnecessarily.
So Charlie, it seems like to be able to do that effectively, probably going back and forth by red lines is not the way to understand their needs.
Brian,
Great question, Brian.
Brian, couple things on that. Absolutely. One, not going back and forth purely by red line doesn't help. And two, you also need to be, the person we're interacting with should actually be, I mean, there is an assumption that that person is equipped to explain the rationale behind the position. And they're not, that's not always the case, right? Many times, and this goes back a little bit to Jeff's question on the lawyers, but many times the people exchanging red lines are not necessarily the people who are given the rationale behind a position. You get a red line saying, this is our position, or this is what we expect. And then if, you know, we're the smaller company on this side and we're kind of, you know, there's a moment where you feel like you're pushing against a wall because you go, wait a minute, I mean, I get your position. Can you explain why? And that's that moment where, you know, the analogy is being on the call with the HP help desk and asking to speak to the manager, right? There comes a time where, you know, we have to tactfully say, okay, thank you. I get that this is your position. Explain, please help me understand what's driving that so that I can work with you to achieve an outcome. And reframing that is very important. And coming back to that with that, you know, help me understand like I'm a 5-year-old, right? That narrative of, you know, you have a position. So Jeff, to your point, how do you go from, because positions start becoming emotional very soon.
Mm-hmm.
There are people who, you know, it's routine to get, I'm doing my job, this is our position. So how do we move from that? And that is where the negotiation, Brian, you brought up an excellent point, right? Just exchanging red lines, you're just going to keep exchanging positions all day. And then red lines get more and more cantankerous because the tone that one reads in a document is always the worst tone one implies. And so part of that is getting, you know, face time. And part of that is ourselves knowing, hey, is this person in front of us even the right person to answer this? Because if they're not, then we have to put in effort and tact to help that person bring another person into the room who can give us that feedback so we can help them craft something that's helpful to both parties.
That's
So
great
this is-
advice. Prashant, can you help us put that in perspective for the smaller companies? You know, as they are working with the larger company, right? That pool of potential people that we should be interacting with is so much bigger. It's probably hard to find the right person. Whereas a startup, you know, there's only a handful of people and it's hard to get it that wrong.
Right, absolutely. So, you know, when we're working on the startup side, dealing with a bigger company, typically by the time you're at the term sheet stage, there is a champion in the bigger company. There's someone pushing in that company, especially in big pharma. If you're getting a deal done, there's got to be a champion for that deal. Otherwise, especially now, given the way the capital market circumstances and the deal flow is, Big Pharma is backed up with several deals, right? So if your deal is coming to the table and the term sheet's coming around, that means there's a champion trying to push things forward. Or it's possible you gave a term sheet and then it sat around for a few months and then finally people are getting onto it. So that's where, Brian, that particular champion, be it the BD person, be it the technology person, that's the person that is going to kind of help massage this conversation a little bit too. And within the BD business development side of the pharma, right, again, there's typically 2 or 3 people involved in putting a deal together. And one person is the person that's kind of taking that first crack at that term sheet. And it's sometimes helpful to say, hey, let's have this call and let's have the individuals on your side, the 2 individuals on your side join Zoom, and I'll have my CEO join the Zoom, right? We can always turn back to my CEO, my board, my COO. I'm bringing 2 people. Why don't you do the same thing? So that is one way, Brian, to approach that picture, to come back to the champion that's moving the deal forward within the company, to come back to the decision maker, if you will, with regard to that deal within the company, without telling the person we're dealing with, hey, come on now, you're not helping, bring someone else. Does that help?
Yes, yes, it does. So people think that I'm a decent negotiator. Little do they know that I was a camel trader in a former life, but I'll share what the things that I look at when faced with negotiations is you have to employ a few techniques. One is active listening. You really have to be able to hear what people are saying. You have to be able to be probative in terms of asking questions that are not insulting, but asking questions that are no longer superficial, but go a layer deeper. You have to be willing to engage in what's called a crucial conversation, something people may not want to divulge in a public setting, but that obviously their interests are such that it's driving their positions. But most of all, you have to possess some emotional intelligence. You have to be able to walk in that person's shoes for a minute or an hour or a day and say, how did you get here? What are the things that are really the motivating factors? And what is it that's bothering you about this particular deal term that we can collaboratively figure a way around? That's my take on negotiating 101. Let's move on to another topic. The transition to a definitive agreement. Everybody is happy. We have signed the non-binding term sheet. You have a happy hour, you're drinking a beer, cold or warm, whatever it is, and now you have to have a definitive agreement. What are the things that the parties should do, and what are the things that parties should not do? Go ahead, Prashant, you start.
Sure. Well, things one should not do: let too much time go between the term sheet and the definitive agreement. Keep moving while things are fresh. 2, don't deviate from that term sheet, even if it's non-binding, or at least don't deviate except for really, really good reason, and and keep that type of deviation very, very rare. 3, this is one where you start with one or the other party will bring a first draft and generally start off from a template, and know what wiggle room you have while going into that situation, and know what is the fastest way to an outcome. So if the term sheet's for a university license, start with the university's agreement template, right? Don't come de novo bringing a new agreement to a university. Similarly, in a pharma negotiation, right? If you're putting a transaction together, then the party that has done several of these transactions will probably have a form that they are bringing to bear to the table. Start with that. And again, move fast. And this is one where I would say, bring lawyers in quick, have lawyers redline to, I would say, only to the extent necessary, right? Because you've already hammered out ideally the big contours of the deal in the term sheet. Then what needs to be fixed in the document? Ideally, with goodwill on both sides, the document is coming together well, and one party is not trying to stick in some gotchas and some weird things in there. But those are the kind of things to watch for, and to really keep it moving and to not end up getting bogged down in very small details as people in my profession are wont to. Know which ones are worth fighting for. And in this thing, Jeff, I would also say, if we're a smaller company, have a budget, have a timeline in mind, and have that ironed out internally beforehand, because this is something that can and will go on forever. I've seen parties go back and forth with term sheets, with actual definitive agreements for months. By the time you're fighting on the last thing, both parties have forgotten what the hell they're even fighting for. And that all comes at a cost, and that's something that I would be very cautious about, is to not create a problem at that last stage.
So Charlie, give us your idea of what a good time frame is from the signing of the non-binding term sheet to the consummation of a definitive agreement, and what are the things that you've seen that have derailed that process?
So, Jeff, the first thing I would say is you also, I'm going to, at the risk of sounding like someone who might be an astrologer, I'm going to say that the time of the year is relevant to this, right? If you're starting to negotiate your definitive agreement in August, you may have a month more delay because, folks may have planned vacations and they're going to take those vacations. And especially if it's with a big pharma, they may not feel compelled to jump on a call with you and work through things. We generally want to see these things buttoned up within 1 to 2 months. As Prashant was saying earlier, you want this to move pretty quickly. Time is a sort of enemy in these things. You really want, to then be able to raise your second glass, as you were saying, Jeff, and celebrate within that 1 to 2 month time frame. One of the things that your lawyers will tell you, and that Prashant, had mentioned earlier, was you can also tell how fast, and how, I think a better term maybe is how much someone wants to do a deal by the time it takes for them to turn a document around and the amount of redlining. So if it's taking an excessively long period of time, unless there's some extraneous situation like vacation, it's telling you that they're slowing down. If they're giving you excessive red lines, it's the same thing. And so if you want to at any point read the tea leaves on how that's going, those are 2 good metrics to look at. But having said that, I would say 1 to 2 months, Jeff.
Okay. We had a question that said, if you sign a non-binding term sheet and things go wrong, that document would inevitably be used in court. Is that correct?
It is a document that signals evidence of intent between the parties. And whenever that question comes up, that's a document that's fair to come up in that context.
And how does one protect oneself? Let's say that it was your intent to have it really as non-binding, and you want to have a way to get out. Is there a way to do that? Or in the crafting of it, you really don't want to get out. Is there a way to make it more binding?
I would say for the first part, it's easier because, you can have all sorts of disclaimers in the document itself, the equivalent of your end user license agreement, right? So footnote with 8-point font. Here it won't be that, but some sort of language in the document indicating exactly that is, this is the party's beliefs at the moment. It may change, et cetera, et cetera, et cetera. In terms of the binding element of it, I think one way to do that is to say, as much as this is a non-binding term sheet, here's the party's intent at the moment. we're going to enter into an agreement. That agreement will be entered into in a certain time frame, and it will reflect these exact points unless the parties mutually agreed that one or other point may be changed. And Jeff, that's a perfectly reasonable thing to do in one of these term sheets, especially in the context of deals that have a time clock attached to them. There are, in the universe that we work in, there are several deals that need to be done within a certain time frame based on certain market pressures. And, you know, for instance, if you're doing a COVID vaccine in 2019, the timing of getting those deals together is paramount. And in that context, one could say that in the non-binding term sheet is to say, yep, we know this is non-binding. However, that being said, we're going to get a deal done in 2 months, and these terms are going to go into that deal unless both parties agree for a term to be changed under condition A, B, and C. So you can get pretty specific there.
Right. The questioner is asking to rephrase it the way that she had originally phrased it. I'm not sure there's a difference, but the quote is, "Isn't it fair to say if it's a signed document between the parties, then it's going to enter into the picture if there's litigation?"
I think that's a fine rule of thumb to go by. You should assume that as you put this document together. Sorry, Charlie, you were starting.
We're going to the exact same place.
Right.
You know, I would say high probability. Nothing in the law is an absolute, right? You know, there are vagaries as to the rules of evidence, right, that might keep certain aspects of it out or only allow it to be used for certain purposes. But having put that asterisk up there, yeah, I think it's more likely than not, as Prashant said, this is going to appear as one of the exhibits in your litigation.
Charlie, I think early on you mentioned a little bit about the spectrum of, you know, relationships that the small companies can have with the larger company in this space, right? Whether it's just a contracted research or manufacturing versus joint venture and so on, you know, exclusivity, et cetera. Can you tell us a little bit more about, you know, the types of arrangements that are made, and, you know, how this would impact these processes with the term sheets, et cetera?
Yes, I think actually, Brian, that may have been Prashant who raised that. So I'm happy to field it if he doesn't want to, but I think he should get first crack at it.
Go ahead, Charlie. I'll follow up after you.
So, Brian, a couple of things, right? Just general rules are that if you're dealing with a big company, there are a few things to keep in mind. The first is that you're less likely to find a champion the further away a particular deal is from the interests of the C-suite. And people who are in big companies and who've been there for a while know that. And so when they're considering whether they're going to champion something and to what degree they're going to champion it, they're saying, how important is this to the C-suite? Because if I get it done, will I be recognized as someone who's achieving, let's say, a fundamental goal of the company? And therefore, will I be rewarded, right? Because, you know, there's only certain ways that companies can reward you with either a new title or with money or with more responsibility to go along with that. So that's the kind of the first point. The second point is, how critical is this to the company? In other words, let's assume that whatever this deal is mission critical to the company. If it is there a workaround for the company, or is this really where the company is being funneled and so they have to go down this road? For example, is there a competitor who can offer something similar that might do so on better terms? Or can they convene a room full of their scientists and engineers and try to, you know, not necessarily work around this, but say to them, you know, if we're stuck with not having this technology, this IP, this whatever it is, this partnership, is there some way that we could patch together a workaround? So I think, you know, that's also really important, because that second exercise, even though it seems like in some ways it could be harmful, if that group of people comes to the conclusion that whatever this deal is important, it strengthens the underlying drivers for the pharma company to get the deal done. And Jeff, you look like you're about to say something.
So I'm just being mindful of time. So I want to just ask the audience, if they have any other questions, please put them in the chat, put them in the Q&A, and we'll see if we can get to them. You know, over the last 2.5 years, technology has been our friend and our foe, in that it has blurred the distinction between a work day and a non-work day. And I find myself, you know, talking to people from early morning hours in India to late morning hours in London, to middle of the day, late day to Australia, and then to Taiwan and other places in the world. This allows us to engage with many different cultures. So I want you to just comment in terms of how the cultural differences that we are engaged now because of the technology either enhances or impairs us in terms of creating this non-binding term sheet, for both timelines and for nurturing that champion that you may not get to meet and shake their hand in person for months after your initial engagement. Who's going to take it?
I think Jeff, that is, well, one that shows what a negotiator you are, but because that I think is perhaps one of the most important elements while constructing a negotiation. And that's where a term sheet is also helpful, because you approach personalities and cultures in bite-sized matters. So what do I mean by that? We know culturally, people in different parts of the world approach negotiations in different ways. And when it comes to some cultures, going back to that point on positions versus what drives those positions, we know in some cultures, a position is all that the party negotiating with you gives the negotiator. So, you know, knowing that early and knowing that they're going to be driven that way, while also culturally something like respect and something like and when I say respect, I mean that in a very formal kind of way, a formal setting and a formal approach to that type of to the negotiation is as important as anything substantive in the document itself, right? Because when you're working cross cultures, this dialogue between companies is really, that dance is also part of that prolonged dating exercise to see if the parties are going to be able to work together. So it's an opportunity for both sides to see if you are indeed compatible. I mean, now, especially the larger companies, even, you know, let's say the larger Japanese companies, many of them are, you know, they're here in Cambridge as much as they are in Japan, but a lot of their positioning, a lot of the culture is driven still from corporate headquarters out in Japan. It is also in those settings important to know you may be negotiating with an individual or a party that, you know, is in Cambridge or is in Japan, but then they will need final sign-off, even on the term sheet, from legal in Tokyo. And we should not be surprised if legal in Tokyo finally comes in, changes all the hard work that you put together for several weeks getting to that point. So these are quirks that are going to show up while we're working globally. And we have to, you know, on that front, I'd say, Jeff, we approach that with as much knowledge as we may have. But again, each interaction is going to be different. We're going to learn something new about that organization, even within its cultural context. and is going to surprise us sometimes in good ways, quite often in bad ways too. And that's just, I think, part of that process, and to have a little bit of wiggle room internally as we approach these things, to know that it is not done till it is done, to always, even when getting impatient, say that in the right way is going to be very important.
Yeah, agreed. Charlie, any last words? You're on mute. You're on mute.
As you well know, Jeff, a couple of observations to piggyback off of that. Japan is desourcing right now. So if you're dealing with Japanese companies, you're much more likely to deal with some branch of the company that is in the US. And as you also well know, because you are an experienced negotiator, if you're dealing with Japan, they're going to want you to kind of reveal your initial positions first. And there will probably be, 3, 5, 7 people in the room. There will be one person who doesn't say a thing. That one person is probably your decision maker, who's just sitting back and observing everything. I think the other thing, which is counterintuitive to many Americans, is that certain cultures expect you, as a matter of politeness, to engage in, for lack of a better term, bickering or dickering over terms. And if you don't do it, it's perceived as, one, not being polite, and two, there's a paranoia on the other side that they've given too much away because you didn't push back on any of it. So as you were saying, and as Prashant was saying, it's good to know as much as you can about your negotiating partner so that you can take these idiosyncrasies in mind and guide your negotiations accordingly.
Well, it is 7 minutes after the hour, so I want to be respectful of people's time. I want to thank our co-sponsor, the GW Technology Office, and Joyce for helping us put on this webinar, and Brian. I want to thank Charlie and Prashant, my attorneys, and really attorneys that exemplify what people should be looking for in an attorney in terms of their empathic, engaging, and knowledgeable understanding of not only the precise science and technology, but how to handle people. And that's the meshing of the art and the science of medicine and business that every entrepreneur in medicine and life science has to learn. That's what SoPE is about. Please join the organization. It is only $80 a year. We have lots of opportunities for you to learn like this and to engage with our community. I look forward to hearing from you if you have questions, and please feel free to reach out to our moderators and our panelists, and thank you for participating today. Thank you all. Joyce, I think you can end the webinar.
Thanks, everyone.
And it will be posted on the SoPE website, www.soapnet.org. We'll have it posted there so you can view it. So thanks, everyone. Be well.